For our fifth and final session, In Good Company, the Corporate Lawyer's Obligations when Dealing with Organizations' Constituents. Next slide. I would like to welcome Patrick Haynes and Virginia Bruner. Patrick Haynes is a partner at Williams Mullen and is based out of our Virginia Beach office. He focuses his practice on handling all manner of disputes that arise from business competition and regulation. His practice has included a broad base of civil and criminal litigation at both trial and appellate levels. He's a member of the litigation section and serves as co-chair of the crisis management, internal investigations, and white collar defense team. Patrick also serves as deputy counsel and chief ethics counsel to our law firm, and since 2024 on the standing committee on legal ethics of the Virginia State Bar. He has taught law students as an adjunct professor at the University of Richmond and Washington and Lee University, and he is a frequent lecturer to bar groups on a variety of legal ethics topics. My colleague Virginia Bruner is also a partner in our litigation section, and she's based out of our Richmond office. She is an experienced trial attorney and litigator. She represents corporations and individuals under investigation by state and federal authorities, as well as internal investigations and compliance matters in Virginia and across the U.S. So on that note, I will go ahead and hand things off to you, Virginia.
Thank you, Julia, and thanks everyone who's made it this far, or just poked in for hours. So we're going to start off today our session with a hypothetical. So the hypothetical is: you are in-house counsel to Acme Corporation, a publicly traded conglomerated manufacturer of certain types of electrical equipment. You have been working with the company for some time, including advising its senior C-suite management, including its CFO, regarding its securities filings. Recently, the company discovered a financial issue affecting a major manufacturing operation and has been working to assess the issue as its next quarterly filings are coming due. The CEO and CFO typically make certifications regarding the company's financial controls as part of the preparation of the quarterly filings. You know that the refusal or delay in signing those certifications can have negative consequences to the company. You also know that making a certification that proves to be misleading can also have consequences to the company, as well as to the CEO and the CFO as individuals. All right, so here's our polling question. Do you have an ethical obligation to provide advice regarding the CEO and CFO's signing of their individual certifications? And if so, to whom? So you can select the company, you can select the CEO and CFO, or both. And we've got less than 30 seconds left. And don't forget that if you want CLE credit, you have to respond to the poll questions. So take your best shot. 10 seconds left. Okay. All right. We're kind of split here. Not many people thought just the CEO and CFO. All right. So we can go to the next slide. So we're going to play out these questions for the rest of the hour, and then we're going to revisit this hypothetical again at the end, and then you can give yourself a grade. So the goals, as we have set out here of our presentation today, is first so that we can understand who the client is when representing an organization, which is trickier than it may seem. Secondly, to distinguish the duties that you owe to the organization versus the constituents at the organization. And third, to apply the best practices in investigations, depositions, and giving advice to your organizational client. With that, I'll turn to Patrick.
All right. Thank you. Good afternoon, Virginia. Can you hear me?
I can hear you.
All right, but my partners, including Virginia, will tell me that's the longest that they've made me stand quietly in the history of the law firm. So I appreciate everyone's time today, and welcome back to CLE Institute. And there's a reason we put your ethics credit at the end, and that's because we know that that's the part that excites you the most. Um, so Virginia and I, the hypothetical that we came up with to start is actually a very common but very vexing situation in the life of a outside counsel to a company in crisis. So we thought where we might begin in talking through the problem here is with the foundation. What is the background foundation of understanding the lawyer's ethical obligations in this situation? So where we start there is what do we mean by the organizational client? And that's a term of art used under the ABA model rules of professional conduct. So rather than company counsel, the concept or the terminology used in model rules is the organizational client. So what do we mean by an organizational client? That term is coined and used in Rule 1.13 of the model rules. And when I say model rules, I think we all know model rules were adopted in the same format that promoted by the ABA in the model rules in all 50 states, but they do vary. They vary significantly from state to state. So we're going to speak today of the language in the model rules, but of course you should consult your local version of those rules for the variations. But Model Rule 1.13 coins the term. An organization is defined as any entity, including corporations, LLCs, governmental organizations, unincorporated associations, and depending on the jurisdiction, may include partnerships. Now, we as lawyers are trained to understand the concept of legal personhood of the corporate entity and the legal significance of the corporate form. But of course, the paradox, why we label it a paradox, is that these organizations act and interact through individual constituents, is the terminology used in Rule 0.13. Constituents are board members, officers, and employees. That's defined in Rule 1.13a. And the lawyer gives advice to these organizations directly through individuals, including those individuals who are authorized to act on the corporation's behalf. So the rule makes clear that what should be implied with respect to the lawyer's need to identify to whom he or she owe their duties as lawyers. The rule explicitly specifies that the actual client is the organization itself, not any individual constituent. With the very significant caveat, however, that the individual may become a co-client so long as that is consistent with the rules regarding conflict of interest. So that is stated in Rule 1.13 in comments 1 and 9. Now, typically lawyers avoid giving legal advice to non-clients about their conduct. In fact, that's sort of a rule one that we all learn, which is don't give legal advice to people who are not your clients. What's unusual here is that when the lawyer represents an organizational client or otherwise communicates through a client's agent, is that the lawyer must convey the extensive advice to individuals who are not our clients, and their advice, and at the same time, the lawyer's advice has legal implications for those non-clients, right? And that's what our hypothetical sets up. So now let's discuss what are the duties the lawyer who represents an organizational client owes with respect to these two different parties in the equation. That is, what are the lawyer's duties to the company and what are the lawyer's duties to these non-client constituents? Can we go to the next slide, please? So the three duties to the organization can be summarized with these three C's. They are Rule 1.1 competence, Rule 1.4 communication, and Rule 2.1 candid advice. So let's start with Rule 1.1. Frequently pointed out that competence is the first rule of ethics. I'm saying that this way with my eyelids because there might be a quiz. The first rule of legal ethics, professional responsibility, is competence. And the rule states very simply, a lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. So in the context of representing an organizational client, to have the legal skill and thoroughness reasonably necessary to that representation means that you must understand that organizations must act through individuals who have their own and often distinct interests in the same matter. So understanding and explaining what those are and how that may impact the decisions to be made by your client is part of competent representation. Rule 1.4 is frequently described as the second of the 5 C's, and that's communication. In relevant part, subsection B states that a lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions about the representation. So again, in the corporate or organizational context, this implies that the lawyer should explain possible consequences and motives that individual constituents may have that are distinct from those of the organization itself. For example, using our hypothetical in the first slide, a lawyer mindful of Rule 1.4 would need to communicate to the relevant decision maker that the CFO and the CEO may reasonably perceive that their own situations regarding the signing of their individual certifications to be different, distinct from those of the company. They may align, but they are distinct. Finally, Rule 2.1, candid advice. And this is often overlooked in understanding a lawyer's duties. As noted above, it requires the lawyer to be candid with the client. And in so doing, the lawyer may refer to considerations that go beyond the law. I mean, go beyond the strictly legal consequences of actions. For example, in our hypothetical, would it be morally right to persuade the CEO or CFO to sign the certification just because the consequences may be less onerous for the company's shareholders? What would be the economic effects, including reputational effects to the client, or the potential disruption if the CEO or CFO is distracted from something involving their own potential exposure for signing a certification that's inaccurate? All of these things are fair game, and in fact, part of your obligation to provide candid advice to your client. So it would seem clear after considering these that the attorney for the company not only can advise the company about these individual consequences, but indeed has an ethical obligation to provide advice regarding the CEO and the CFO's signing of their individual certifications. So we now know that everyone who answered A to the question might be right. The question will be, we eliminate B and C because we have an obligation to the company. So 3% of you fail and have to go to summer school. But now we'll move on through some of the rest of the background to considering whether the right answer is A or C. Next slide, please. What I'm going to turn to now is what I said, the other side of the coin. What are our duties to constituents of the organization who are not, at this point, our clients? So The main duties to non-clients arise out of rules 4.1 and 4.3 of the rules, and also an adjunct we'll talk about that's in one of the subparts of the organizational rule 1.13. But start with 4.1, truthfulness. Truthfulness in statements to others is actually the title of the rule. In relevant part, in the course of representing a client, a lawyer shall not knowingly make a false statement of material fact or law to a third person. So in our scenario, what that means is the lawyer cannot, of course, be untruthful with the CEO or CFO in order to persuade them that they should sign the certification. The lawyer would violate this rule if he or she said, for example, you don't have to worry about signing the certificate. All of the statements are verifiable and true. If the lawyer, in an extreme example, knows that, in fact, they are not true. So that's one, the rule of truthfulness, which applies to clients and non-clients alike. Rule 4.3 is dealing with unrepresented persons. And the real key of Rule 4.3 in terms of dealing with people who are not your client is the duty to correct the misunderstanding that may exist when lawyers are speaking with non-clients. Virginia's shaking her head because in the white collar group and in government investigations, we're confronting this all the time. Again, you're dealing with constituents very often of a organizational client who are the critical witnesses. They are the people that we have to speak with to get to the facts, to give our clients the right advice. And the employees of the company understand, or they know, you're counsel for the company, but that can shift from time to time into a misunderstanding that you're there to protect them and protect their interests. And so we're shaking our heads because Rule 4.3 is something we're really familiar with. It applies, for example, in our representation and in our hypothetical, if the CEO or CFO is not represented by their own attorney. So the rule in full on the screen, in dealing on behalf of a client, which we're doing in this scenario, with a person who's not represented by counsel in the room, or not represented by counsel, excuse me, a lawyer shall not state or imply that the lawyer is disinterested, right? We're not disinterested, we're counsel for the company. When the lawyer knows or reasonably should know that the unrepresented person misunderstands the lawyer's role in the matter, the lawyer shall make reasonable efforts to correct the misunderstanding. The lawyer shall not give legal advice to an unrepresented person other than the advice to secure counsel, if the lawyer knows or reasonably should know that the interests of such person are or have a reasonable possibility of being in conflict with the interests of the client. So in our scenario, this implies a lot, but in our scenario, this implies that you, as the organization's lawyer, cannot simply ignore if the CEO says to you after you've advised him or her about the certification, well, you must know this better than me, and I'm glad that I have your legal advice that I should sign it. Even if the lawyer did nothing to state or imply that she represents the CEO's statement indicates that the CEO she misunderstands the lawyer's role. The lawyer then has two clear obligations. First, to correct the misunderstanding by reminding the CEO that she represents the company and not the CEO. And second, the lawyer can't give legal advice to the CEO. For example, to say, I think you should just go ahead and sign it. Next slide, please. And lastly, a subsection of Rule 1.3 on organizational clients really just complements and further specifies this same requirement of disclosure of your role to constituents. Rule 1.13F requires you clarify your role when interacting with these individual constituents. In dealing with the organization's directors, officers, employees, members, shareholders, or other constituents, a lawyer shall explain the identity of the client when the lawyer knows or reasonably should know that the organization's interests are adverse to those of the constituent with whom the lawyer is dealing. Okay?
Yeah, and so, one hard question, which the text of 1.13F and 4.3 doesn't explicitly address, is whether the lawyer has an affirmative obligation. So at this point, to tell the CEO, hey, you should probably get your own lawyer to talk to about this, which is something, Patrick knows comes up frequently with internal investigations, which we're going to cover more shortly, but whether, you're either feeling like, do I have to tell them to get a lawyer? Or in some situations they ask you, do I need my own lawyer? But so since these rules don't, explicitly answer that question, so what is the ethical framework that the lawyer has to resolve that thorny question?
Yeah. Now, that's a very good question. And it comes up, as you know, Virginia, fairly frequently. When you have enough experience, you know to begin discussing this with your organizational client, with your representatives, before you're in the room, hopefully interviewing their constituents, because you'll want to game this out and you'll want to talk to the organizational client about the choice to be made. And the choice to be made under Rule 4.3, as we said, is you can sit silent as long as you've clarified you're representing the company and not that person whose interests you reasonably believe may be adverse to the company. Or, you may advise them to get their own lawyer. You can't give them legal advice, but you can do one of those two things. Rule 4.3 doesn't prohibit you from sitting there silently, but a lot of clients are understandably concerned about that. Well, maybe my CEO should have their individual lawyer at that point. The ethical framework is that while there's no mandatory duty of the lawyer to tell a non-client that they should get their own lawyer, there's no prohibition on doing so if it would not be inconsistent with the interests of the client to whom you owe your sole duty of loyalty, right? If it's not inconsistent with the interests of the company to tell CEO, you should really get your own lawyer now, then there's no prohibition on it. And there are certainly many situations where I would advise a client just that, look, that's really at that point in your best interests, as well as the CEO's, because we can work with that CEO's lawyer, but we want this person to be well advised. We don't want them to act in a way that's not in their best interests, and which incidentally would probably not be in the best interest of the company as well. And again, remember, we can consider and give our client candid advice under Rule 2.1 that considers all the consequences, reputational, individual consequences. But frankly, just thinking about it from the company's best interest is if those interests are adverse and it's going that direction potentially, it's still in the best interest that CEO has good legal representation. So again, the answer may be different and the advice may be different depending on what stage of the matter you are in. For example, are we at the stage of an initial fact-finding interview, or are we at the verge of the employee incriminating themselves in a way that could have serious repercussions to the company itself? So the lawyer owes his or her best advice to the client, in this case, again, the organizational client, and to help the client decide if the CEO should now be told it's time to lawyer up. Now, Virginia, I'm interested in sort of your thoughts on that and your experience.
Yeah, no, I agree. I think it's when at the outset that you could have, an officer, director, an employee with an adverse interest to the client. I think that that's one of the first conversations you want to have when you're embarking on an internal investigation is, do we think that any of these people need their own attorney? And it might be something, where you revisit it as it goes on. It might not be apparent in the beginning of the internal investigation, but, as you know, you may learn of things or have as the investigation goes on, you might want to say, actually, you know what, I think we should advise them to get their own counsel at this point. All right, so let's go to the next slide and see how this actually plays out in practice. So in our next, so one application or one scenario we looked at is to apply some of this ethical framework we have laid out is when the outside counsel is interviewing the organization's employees about past conduct. So this is the typical internal investigation, which Patrick and I know well, where you have outside counsel come in, do an investigation to try and obtain information that is needed to advise the organization's decision makers about how to deal with allegations of misconduct that could be attributable to the organization. So this is the fact pattern in the most well-known case regarding the scope of attorney-client privilege in the corporate context, Upjohn versus United States, which white-collar practitioners know well. So that case has given its name to a very important technique for addressing the attorney's ethical obligations, while at the same time taking appropriate steps to preserve the organization's prerogatives and its attorney-client privilege. And that was the actual subject of the Upjohn case. So that technique, known as the Upjohn warnings, is what prudent counsel do. Usually it's at the very beginning or very close to after you say hello. Of any interview with a corporate constituent. So the exact words may vary, but there's three really important things that you want to get out with your Upjohn warning. First, letting them know that the counsel, you're retained by the organization. You do not represent the employee. Second, to advise them that the attorney-client privilege does cover the attorney's communications with the employee. It does cover that conversation with them, but critically, that privilege belongs to the organization, and the organization can choose to waive that privilege and disclose information that they learn from that interview, and they can do that without the employee's consent or heads up. So, so going in the very beginning, giving that Upjohn warning when you're doing an internal investigation is really critical to advise them of these obligations. So then, Patrick, can you talk a little bit about some of the issues and considerations that come up with respect to confidentiality? Oh, you're muted, Patrick.
Okay, yes, next slide, please. So, and congratulations, Virginia. I should have a duck drop out and for the magic word that Virginia just said. And yes, I'm dating myself. I'm actually dating my mother with that reference to an old television game show called You Bet Your Life. But you just identified the third of the 5 C's in legal ethics, confidentiality. So you can collect your prize on the way out today. As you indicated in your outline of a good Upjohn warning, a key here is the privilege in an interview situation belonging to the company, not to the individual. Touching on some of the ethical obligations that we've outlined, preserving privilege is part of the attorney's duty of competency. But it's also important to avoid a misunderstanding that could compromise the company's prerogative to either maintain its privilege or to waive it at its choice, should it decide in its best interest to do so. That can be critically important if the company is ever in civil or criminal litigation and wants to choose its own information in defense or in mitigation. So, again, critical part of your obligation of competency to both protect the privilege for the purpose of maintaining that option for the company. Now, serious problems have arisen and can arise if the attorney is not clear, if the attorney fails to inform the employee that there's not an individual privilege because you do not represent the employee. The employee can later seek to prevent the company and the company's lawyer from using the information that the employee now asserts it relayed in confidence, believing that the attorney was representing the employee's interest and that it was privileged between the attorney and the employee. And the case law is replete with examples of the consequences of such mistakes. So The attorney who's in the best position to do so must clarify the privilege and confidentiality rights of the parties involved. Now, it's clear that simply the fact that the attorney represents the company does not in and of itself prevent the attorney from also forming an attorney-client representation with the individual constituent. That, by the way, is expressed and stated in Rule 0.13. The attorney may do so, subject to Rule 1.7 governing conflicts of interest. And by the way, you've now heard the fourth of the 5 C's, conflicts of interest. We're going to talk about that next in the context of another scenario or application of our principles. Next slide, and Virginia.
Thanks, Patrick. All right, so I want to talk a bit about the implications involved when an attorney for the organization participates in a deposition, in testimony, or some either formal or informal interview of an employee or an officer by a third party. So I'm not doing the interviewing now, someone else is. This can come up in litigation, of course, that could involve the corporate entity, but it can also be an interview with government bodies like DOJ or the SEC. So going into that, the attorney should start with the default position that his or her role is representing the organization, not the individual. And that's what Rule 1.13 says in the comments. But those comments also make clear that the attorney can also represent the individual officer or employee if that's the intent. So if outside counsel is going to represent the corporation and the employee, it's got to be first explicitly agreed upon. Second, it has to be free from conflicts. And third, preferably confirmed in writing. So as to the first of those, it's really important to be very clear and explicit with the individual and the organizational client. So you can attend the deposition or the interview as the counsel for the organization, and you can leave that individual unrepresented for that depo or the interview, or the company can get them separate representation. But if you agree to represent the individual for that deposition or that interview, even if it's appropriately limited in scope just to the deposition or the interview itself, that is a joint representation. It's not a common interest or like a joint defense situation where you have different parties and they're represented by separate counsel, but it's a joint representation where a single lawyer or firm is representing more than one client in the same matter. So then when you are considering whether it's permissible ethically to enter into a joint representation, you need to consider the likelihood of a conflict of interest. So one example would be if the employee or the officer's testimony may implicate them personally, but that could benefit the organization. That's a conflict. An attorney cannot represent both clients if the employee faces personal liability or intends to assert legal or factual positions adverse to the positions to be taken by the organization. And you have to consider whether the attorney will ever need to cross-examine the employee later in the proceeding. Usually if you're cross-examining someone, you are adverse. So that should be a flag. A different kind of duck or animal should be dropping down from your ceiling.
Yeah, cross-examination. Yeah.
Right, exactly. So next slide, please. So then finally, the attorney has to consider and disclose issues of confidentiality and privilege. You need to clarify who holds that privilege and the right to waive it. And whether information that's learned from the individual will be shared with the organizational client unless the employee directs you otherwise. And if the dual representation ends, unless the employee has validly consented to sharing it, Rule 1.9 limits the use of that information against the former individual client. So if you're just representing the individual for the purpose of the interview, what happens to information you've learned during that interview? So next slide. So if you take all that together, there's advantages and there's disadvantages to both of those choices. And those have to be explained to the organizational client, who is your first client and who's entitled to your guidance. So that conversation has to be had. There are key lessons to avoid pitfalls that can occur regardless of this representational choice. So in other words, regardless of the decision to expand your representation to the individual, you have to take care to first be explicit about your representation so that constituents do not assume you represent them personally until and unless you and the organization have decided to do so. If you choose to remain only counsel for the company, you have to tell that to the constituents at the outset and repeat it various times, various settings. So for example, when you're interviewing someone or having, it is an interview or you think of it more of a conversation, you tell them the first time, tell them the second time. So the third, say, hey, I know we've been over this before, just a reminder, don't represent you individually. If the interests of the organization and the individual start to diverge, do not ignore it. You have to deal with it. And document what you disclose about your representation status, both to the individual and to the organization you represent, including something as simple as put it in your interview memos, put it in your interview notes of the interview. Number one, that you gave the upjohn. All right, Patrick.
Yeah. All right. Thank you, Virginia. So pulling all this together, I want to talk a little bit about the ABA formal opinion that was issued at the beginning of this year, that synthesizes a lot of these lessons and is sort of the impetus and inspiration in some ways for today's presentation and choice of topic. ABA formal opinion number 514 came out on January 8th. And as it says in its preamble, the opinion focuses on this very situation where a lawyer, whether in-house or outside counsel, is giving advice to an organization client through a constituent about the future action that the organization may choose to take. The lawyer knows or reasonably knows the constituents are likely to have their own legal interests. So, and the hypothetical is an embodiment of this. And in the situation where the lawyer does not intend to create that separate attorney-client relationship with the constituent, or otherwise assume duties directly with the constituent. And then the ABA opinion walks you through this same framework that we discussed today and reaches the same conclusions we talked about. That the duty to competently advise your organization includes a duty to advise the company about the implications of its proposed conduct for its constituents. And then the flip side, what are the rules, regulation of the lawyers dealing with non-clients? The examples given in the opinion include advising organization officials regarding making government filings, such as the one we discussed in our hypothetical. The key findings and conclusions of the opinions are these four. First, to the extent the individual has personal legal interests at stake, those interests may be largely aligned with the organization, but there may be differences in the tolerance for risk. The individual may have an interest in proceeding carefully, for example, in signing that certification, because the personal cost of being accused of misconduct will be very high for them. Second, the lawyers may have an affirmative duty to give competent advice to the organization, right? That's the one we've talked about all afternoon. Third, this duty is especially relevant if the constituents face this potential civil or criminal liability for actions they may take in the course of the company's business. So this has heightened implications not only for the individual, but also for the organization that employs them, right? As opposed with an action that does not pose this substantial risk of creating a dual exposure. And fourth, the duty still applies when the lawyer doesn't intend to form that attorney-client relationship with the individual. Because again, these consequences to the individual constituents is a material consideration for the organization itself in making an informed choice about how to proceed. So we're going to give you a series of takeaways on the next slide. If you can go to the next slide, please. Our takeaways from all of this, trying to boil it down, of this situation where you have organizational client constituents, some difference in interests, maybe aligned, but maybe distinct, and some risk of exposure to both organizations. First takeaway, default, the organization is the client. Second takeaway, those duties differ for the entity versus the constituents. The third, always give up John warnings in investigations. Always, always, always. And by the way, for my in-house friends out there, there are many ways to give up John warnings. They don't all have to sound like Miranda warnings being given by someone who happens to wear, a coat and tie. The importance is the substance of the communication, and then being mindful under Rule 4.3 of making sure to reinforce it when necessary to avoid a misunderstanding. That's all it is. There's no magic to it. It's just needs to be said. And to be clear, give those upjohn warnings in investigation and be clear about privilege ownership when giving those disclosures. The next, confirm the attorney role and representation early and often, or as often as necessary to avoid misunderstandings. Advise organizational leadership of risks to the individuals. In joint representations, watch for conflicts. Again, we could do this in that interview or deposition scenario. We can choose whether to do it or not to do it. There are options available. If you choose to do it, you got to watch for conflicts, and you got to watch for ensuring that information, you're not limited in your representation of the corporation as a result of your duties to the individual who you agreed to represent for that interview only. And last, document the communications that you made. All right, we have just a little time for one reprise of our hypothetical. We're going to give everyone a retest here on Friday afternoon. It's think of it as a way to raise your grade. Although, frankly, I think there were pretty good grades on the untutored test, but you get a chance to do a makeup test on Friday afternoon, and then we're going to have a little bonus. All right, so let's go ahead and do a revote on our scenario. Same scenario. There's no new tricks and no new facts that we've snuck in here on the last slide. Same scenario. Do you have an ethical obligation to provide advice regarding the CEO and CFO's signing? I already told you the answer to that. And if so, to whom? So 30 seconds remaining. Everyone record your vote.
Yeah, get that credit.
Yeah, get your credit. This is actually more of a grade for me in Virginia, because if the numbers haven't changed, we may not have.
We're out.
10 seconds remaining. 10 more seconds till we close this vote. All right. I think we're ready. And look at that. The numbers did improve. We have an ethical obligation to the company. That went from, I think, 50% up to 57%. So good job. Whether we have the duty to the CEO and the CFO, we actually, I don't know. We may have to go back to remedial, a little bit of remedial for me in Virginia. And maybe the question's misunderstood, because the point of the opinion is your duty is to give the advice to the company, which is our organizational client. I don't have a duty to give the advice to the CEO and CFO, but it may be in the best interest of the company that I do that. And both, that answer in our scenario is not correct, because technically, because we haven't agreed to represent them, And the company hasn't yet authorized us to represent the CEO and CFO individually.
Yeah, so I guess Patrick, maybe to put like a finer point on it for folks. So if you represent the company, the obligation is to the company to provide advice, right? First and
Yeah.
foremost.
Right.
And then if you think that the CEO and CFO, because here they may have an adverse interest, they may have personal repercussions if they're signing something that could be false, is it's one option, discuss with the company whether or not you should provide advice, and another option would be maybe we advise them to get their own counsel.
Mm-hmm. True. But I guess, and maybe the trick of it is, I don't have an ethical obligation to do that directly to give that advice to the CEO and CFO, unless it is in the best interest, it's fulfilling my ethical obligation to my client, which is the company. That's the key distinction.
Yeah.
If that makes sense. So, all right. Well, listen, we want to give you our bonus also. Next slide, please. This is a quick little bonus, a Friday afternoon. In this presentation, we mentioned that legal ethics is sometimes boiled down to or simplified into a set of 5 words that each begin with the letter C. If you were paying extra close attention today, you would have heard us identify 4 of the 5 C terms in the presentation: competence, communication, conflicts, and confidentiality. Although there are variations depending on the source and authority you look at, which of the following is most commonly cited as the 5th C? 30 seconds remaining. The choices are candor, control, or cash. Candor, control, or cash. Most commonly cited as the 5th of the 5 C's of ethics. 10 seconds remaining. As you can imagine, there are a lot of different commentators who have different answers, although one is definitely predominant. All right, let's see what our results are. Candor came in at 89%. That is, by the way, the most frequently identified 5th C. And strongest case remains, in my view, for that. Trustworthiness and credibility simply are too central to the unique role we have as attorneys to go without mention. I could make a case that management, if you can put those results back up, because nobody is wrong here, I can make a case that the management of client funds and fees are sufficiently important topics in legal ethics that cash should be considered, particularly maybe if there was 6th C status, like the 5th Beetle. Maybe it would be cash, and we had 5 of you who identified that. Control seems somewhat more attenuated, but would imply a number of issues that are addressed by ethical rules, such as who is the client, what decisions are to be made solely by the attorney, and which ones are client decisions and the like. So I think a case could be made that the 9% also would qualify, but most of you are right in terms of the greater weight of authority.
Right.
And that is our presentation. If anyone has any questions or if they could be relayed, I don't.
And while we're waiting to see, I guess, if we have any questions, since we have a couple minutes, I can ask you a question, Patrick.
Oh.
Sometimes when you have like an investigation, or you're hired by a company to conduct an investigation because of allegations of wrongdoing, you have issues of trying to figure out who is the person with decision-making authority at the company. Especially tricky when you have, CEO, CFO, or someone on the board who's, a witness or is implicated in some ways. I would imagine it can be awkward in trying to figure out, or say, maybe you shouldn't be part of this conversation. So how do you advise in-house counsel to help negotiate that situation, and outside counsel?
Yeah. Well, what I typically would do in the situation of our hypothetical, where it's a publicly traded company, this is a potential material issue for disclosures and certifications that are upcoming. I mean, typically what you're going to advise is the safest thing to do is to have a special committee of the board control your investigation. What then becomes somewhat tricky and is not barred by the rule, but you want to think it through and have clarity about it. You know, obviously the CEO doesn't cease to be running the company. In our fact situation, the CEO is not implicated in the wrongdoing, but they are going to have potentially distinct interests. But they haven't stopped running the company. They need to be informed as the investigation is going along about facts that are important to the operation of the company. So what I typically advise in-house is in that situation, we're probably going to be working at the direction of a board or a board committee. But that board committee should consider with us when it's appropriate to give briefings to management of the company. Let them continue to manage the company, let them continue to run it. And that includes providing them information that they need to know about the course of the investigation and the decisions the company has to make. So the advice is to determine that up front and then again, consistently talk about the information. Because remember, it's a two-way street. It's the information we're getting in the directions of the investigation, and then it's also giving information back to the client about the decisions that are to be made. So the CEO may not be involved in giving the direction, but that doesn't mean that they can't get information if it's appropriate to share with them.
Right. We did get a couple of questions, and I think we have a few more minutes. So one, is there any difference in the hypothetical or in the advice that this is a private company? I mean, my sense is there's nothing in the ethical rules that I think varies based off of that we've talked about today versus if it's private versus public.
Yeah, that's right. And we could envision, and there are situations where, you know, managers or individual constituents of a private company still have consequences that they can suffer that are distinct potentially of those of the company also.
Okay. We've got one more. So under the hypothetical, the CEO/CFO are signing on behalf of the corporation in their corporate capacities. It seems like splitting hairs to say you're advising them personally when you talk to them about the rules regarding certifications. I'll just note and then turn over to Patrick, who's the expert. In terms of like their potential liability, if they sign a document if they were to sign a document that's false, they could be personally, civilly or criminally liable for that. So there is like personal consequences, but I think the rules about certifications would be more advice that you could give on behalf of the company. Is that?
Yeah, I think you put your finger on it. There are distinct consequences for them as individuals of signing a certification that's false or that perhaps they have a reason to know is false. Yes, they're doing it. Everything they do with their CEO hat on is on behalf of the company in a sense, or within the scope of, their corporate duties. But they have consequences: civil, criminal, reputational, being barred by the SEC or by another regulator of being in a C-suite position. So even though they're doing it based on corporate, on their corporate role, there's still individual consequences where their tolerance could be different than the company's tolerance.
Right. And we'll do time for one more, Julia. So another question was, I think this is speaking to the question I had asked about, you might have to have like a board committee or something to be the decision maker over the investigation. The question is, if you just may not have a board committee, if you may not have sufficient independent board members, what to do?
So just a couple of thoughts out there, and it depends on the bylaws and the corporate laws and the jurisdiction where it's formed. But there's some circumstances where the company can appoint independent representatives who aren't on the board, or appoint a committee of management that may not be board members, but can be considered disinterested. A big reason for doing the disinterested board, situation, as many of our, listeners know, have to do with derivative lawsuits and appropriate defenses to derivative lawsuits that may come out of the situation. But it also can have, has implications under the securities laws and just for mitigation in terms of the sufficiency of the company's investigation, maintaining that it was sufficiently independent of management. So there are a variety of mechanisms that that companies can use. You just have to consider the specific derivative litigation defenses and what the company's bylaws and the state laws allow you to do.
Well, it looks like we're out of time. So thanks everybody for joining Patrick and I here. And if we didn't answer your question, we'll reach out to you to follow up directly, and then I'll hand it off to Julia.
Awesome. Thank you so much, Patrick and Virginia. Everyone, that concludes our CLE Institute 2025 program. Thank you all again for joining us.